Morning, Ryan. Will Capital.
Good morning, Your Honor. Teddy Parker on behalf of the plaintiff.
Good morning.
Good morning, Your Honor. Tyler Watson on behalf of Real Water.
Good morning.
Morning, Your Honor. Jim Cavanaugh with Gordon Reeves for ETT one DBA Terrible Herbst.
Good morning, Your Honor. Online, Colt Dodrill, Bar 9000, counsel for Nevada Beverage.
Good morning. Okay, so Real Water's motion to continue. Reviewed that, the plaintiff's opposition, defendant's reply. Welcome arguments begin with defendants.
Thank you, Your Honor. In some, defendants are seeking an adequate and fair period of time to conduct discovery on what is a brand new wrongful death case that's been brought into the Shaparov claims. Complaint was filed at the end of February of this year. Real Water was served as the end of March of this year, answered in the middle of April. The motion to consolidate was filed on April 21st of this year. The order was actually entered on that consolidation motion on May 28th, so very recently. Prior to that, no ECC had been conducted. Discovery had not been opened prior to that time. Most recently, plaintiffs have disclosed, I think it's on May 30th, additional records related to Mr. Herbst's medical treatment. And that came over the several supplements that have been received. We have about 9,000 pages of medical records that have been disclosed to date. These are records that date back from 2016 all the way to decedent's death at the end of 2024. Obviously, defendants should be allowed adequate time to subpoena the medical records on their own. We know additional records have come as recently as 2 weeks. We're not sure if we've received everything from plaintiffs, but we know additional time is necessary for our own subpoenas to be issued. We also are going to need to be able to submit our own written discovery requests, assess expert needs, vet experts, produce voluminous records to these experts to allow them adequate time to prepare their opinions. And all of these tasks can't be truncated or performed any faster than what we're proposing. We're seeking an April trial stack. This would afford defendants approximately 6 months to get their initial expert disclosures put together. And it would be a total of approximately 8 months of discovery on a brand new wrongful death case. That's aggressive. That's not an attempt to delay or kick this out. We're happy to try this in April, but that's a really fast turnaround on a wrongful death case. Currently, our expert disclosure deadlines are due on Monday. That clearly will not work for us. And so we would ask that the court simply take into consideration that defendants do need adequate time to be able to defend themselves, produce expert reports, and prepare for trial. Thank you, Your Honor.
Thank you. Anybody else on the defense side?
Thank you, Your Honor. Colt Dodrill, Bar 9000, counsel for Nevada Beverage. I'll be brief. Since the Milo Herbst estate case was recently filed, it does not pose a 5-year problem. And to the extent it does, perhaps consolidation was not the appropriate action here, but it was the plaintiffs that took that, and we agree that April would be the best time for the trial. That's still aggressive, but perhaps doable. And one word on the medical records: Mr. Herbst's medical records show he had cirrhosis in 2016. The defendants are trying to conduct discovery so that we can obtain, if they are available, prior medical records so that we can determine when this cirrhosis developed, as that will affect the causation arguments at trial.
Thank you. Anything from plaintiffs?
Yeah.
Oh, did you?
Sorry. Yeah, it was a joint motion, Your Honor. I would just simply say the bottom line here is defendants simply or reasonably seeking adequate time to conduct discovery and prepare for trial. And a continuance of both those parts of this litigation is necessary in the Herbst matter.
Thank you. Thank you.
Yes, Judge, to start, I think we should remember that all the liability discovery is done. We've done all the liability discovery on real water, tried the case 5 times. We've done all the liability discovery on Nevada Beverage and Terrible Herbst. With regards to the other plaintiffs, all of them have been deposed except 2 that are going to be deposed in the immediate future. So what we're really talking about is the Hearst case, the damages case. We have produced all the medical records, comprehensive productions. So we've offered the heirs for depositions. They refused. I'm assume they're going to take them in the near future. So what they're really talking about doing is preparing damages and get a causation expert on one death case. And I think it's pretty clear what they're going to do. They say in their papers, alcohol. That's what they're going to come with. I mean, they could do the expert report now. I could do the expert deposition tomorrow if I had to. So it's really not that extensive. It's nothing that hasn't been done in prior cases before. We would really prefer to stick with the October stack, November 3rd, but we can see the handwriting on the wall. I think the court's inclined to move us to January. If it is moved to January, the defendants have ample time here to do anything they want to do. And if they can't get it done, they can file a motion at the end of the discovery period and ask for further time. But if they wanted to get it done, they could have got it done by now, but they don't really want to get it done. But in any event, if we do move to January, we noted that we have the Martin Luther King holiday there on Monday, January 19th. So I looked at the previous real water trial that we tried here, the Wren case, and that took us 14 days from the very beginning of voir dire till when the verdict was delivered. So I think this case maybe be a little more compressed than that, but let's just use that as a model. So we think it'd be, if we started this case on January 20th, that'd be Tuesday. That way we wouldn't be doing voir dire and have all the jurors tell us that they have plans for the 3-day vacation that can't be here. So that would be our concession to the motion, Your Honor. And if you did do it January 20th, it's June 11th now. I mean, that's
6 months.
more than 6 months, Your Honor. It's seven months from now to do damages discovery on one death case. So I don't, with 3 different defense firms, I would point out, we've already provided comprehensive medical records, including the imaging. I already provided the imaging to them. So that would be our proposal, Your Honor, that would be set at that point in time.
Thank you. Any rebuttals?
Yes, Your Honor. The January stack, by my estimation, and I believe my colleagues on the defense side would agree, would be too truncated to allow us to adequately conduct discovery. That would give us 3 months to get expert reports disclosed, and at best about 5 months of complete discovery time for a death case. Again, we're trying to be reasonable. We're trying to be exceedingly aggressive to get these cases ready to go. We're not trying to push these out far into the future, but breathing room of 6 months to get expert discovery put together and 8 months of total discovery on a death case is not a delay tactic. This is a concession that we want to be aggressive. We want to try these cases as well. We have to have adequate time to actually defend ourselves and present our defenses. Thank you, Your Honor.
Thank you.
Your Honor,
Go
Colt
ahead.
Dodrill, counsel for Nevada Beverage. We've not been a party to any of the prior trials, so I'm not sure plaintiff's counsel's representation that all the liability has been established. There may be additional experts on liability, and I think that the 2-week frame he's looking at on trial in the Wren case, I think Real Water may have been the only folks in that case, and I would suggest that with additional defendants, 1 retailer and 1 distributor, that this trial will take longer than 14 days to try.
Thank you. Anybody else?
Cavanaugh for TT1 Terrible Herbst. I agree. We were not parties to any of the prior trials. And we believe this death case will take longer than 14 days.
Your Honor, may I address that last comment?
There's no need. Thank you.
Okay, good.
Thank you for asking.
Thank you.
Yeah, so court's going to we'll call it granted part, denied part, defense motion to continue, granted, yes, I'm continuing the trial denied in part because I'm continuing your trial to our January 2026 stack with the presumed emphasis there, January 20th, 2026. You know, that I was going to say these aren't rocket science, but that might not be appropriate in this case. You know, plaintiff's points are well taken. I mean, one, that's 7 months from now. Two, you know, whether these entities who didn't go to trial already in any of the other cases, you know, we're not in those other cases prior to trials, but there's no real mystery given that how many trials, 5 trials already? Five. Yeah. Everybody knows the issues, everybody knows who the, you know, majority at least of the experts are. There's good cause shown to continue. There's also, however, good cause given the age of the some of the plaintiff cases that continue to January. That gives plenty of time to conduct discovery, because discovery's already begun in earnest, which is an understatement. So we'll give you an amended trial order, but you'll be on our January 5, 2026 trial stack. It's a 5-week stack, presumed start date for you all, January 2026. Last day to file any type of pretrial motion, November 10, 25. Pretrial and calendar call, same date and time, and that is December 17, 8:30. Pretrial status check 9:30 a.m. November 12th. Pretrial memorandum due on or before December 12th, 2025. We'll give you an order that has all that in there. To stay proactive and make sure things are moving along. I'd like to bring you back just on a status check, discovery and case status. Maybe like mid-July, you know, a month from now, essentially, maybe July 16, unless anybody has any issues with that date. So July 16, 9 a.m. Status check, discovering case status. We'll need a written order on the motion. So Mr. Watson, go ahead and prepare that order, grant part, deny part, circulate to everybody for review and approval. And I'll see you July 16, 9 a.m.
I'm sorry, Your Honor, just for.
I'm sorry.
Go ahead,
Tyler,
first.
Your Honor, one point, since you're tasking the defendant with the obligation of preparing the order, can we make sure the order reflects that in fact Terrible Herbst was a part of the second trial? That's the only thing I wanted to comment on. I think there was mistakenly.
I apologize, and
That predated Mr. Cavanaugh's time.
it did, and I should know better.
No,
It wasn't a complete participation.
I know it wasn't intentional.
It settled, but in the middle of it, but
So it began. I mean, I'm not sure that makes a difference, but sure. And then there was a question on your side.
Yes, my question, I apologize if I missed it. Did you speak to initial expert disclosure and rebuttal expert
Oh,
disclosure?
yeah. So good
I think
question.
you probably better we sit down with the defendants and move those.
That's what I was gonna say. So I meant to say, because that is I meant to say and I forgot, so thank you for asking. So prior to July 16, we can confer good faith work on your discovery schedule, backing out from the trial. It'd be helpful for me if you all have, you know, something filed prior to July 16 that I can look at and say, okay, yeah, you're moving along. Does that answer your question?
Yeah, I just want to make sure that at least for the record, Monday is not our initial expert.
That's correct. Yeah, that's correct.
Appreciate your
Yeah, yeah, yeah. Okay, thank
Good
you.
morning, Your Honor.
Thank you.
Judge.
Thank you.